The network made an unparalleled contribution to quality, diversity, and equity by hosting guest talks with judges from the Supreme Court of Ukraine during the Russia-Ukraine war, as well as the Supreme Constitutional Court of Palestine and Supreme Court of Israel during the peak of the Middle East crisis. 70% of participants during Global South Network activities since its launch in March 2023 were women. We demonstrate the Global South is not a passive recipient of ideas but an active contributor shaping global norms. Today we are privileged to host Honourable Justice Michail Pikramenos, President of the Hellenic Council of State, Supreme Administrative Court of Greece.
I don't like the long presentations and the long speeches. Dialogue is better than monologue. The case law of the Court of Justice, the European Union and the Strasbourg Court has been instrumental in modernizing national approach to important issues in the field of rights. There is a violation of the European law. The Special Supreme Court, our court, was wrong, in very simple words. Public trust in the European judiciary varies significantly from country to country. However, the level of trust cannot be viewed as distinct from the general differences between high trust societies, mainly in the northwest of Europe, and low trust societies, mainly in the south and east. Historical, social, and economic reasons account for these differences. Trust is the bedrock of any successful operation, whether it be private or state. Judiciary is not in competition with other branches of power, but it is fundamental that trust established and there is a recognition of its independence in the way of its function.
Deseo expresar mi sincero agradecimiento al Dr. Naumen Riaet, la conferencia dada por el magistrado Michail Pikramenos, presidente del Consejo de Estado Helénico de Grecia.
Dr. Naumen Riaet, the founder and convener of the Global South Network, his visionary leadership has established a vibrant forum where judges, academics, and practitioners from around the world can share and exchange ideas. Initiatives like today's dialogue allow us to compare jurisprudence, share best practices, and develop common principles. This has the potential to contribute to transnational standards in procedure and enhance administrative law globally.
I would like to point out that Dr. Riaet's initiatives have not only enriched comparative judicial dialogue, have also fostered mutual understanding of the diverse challenges that courts face in safeguarding the rule of law and constitutionalism. In these days of backsliding of the rule of law, rising authoritarianism and polarization, it is of utmost importance to strengthen mutual understanding and trust.
Despite the fact that Russian armed forces have been near Kiev, the Cassation Court did not stop its operation concerning judicial proceedings and continued its work. Despite the Russian invasion and air alarms, other horrible things of war in all our Ukrainian regions. To express my appreciation for your assistance, for your help in our fight against unjustified war.
Supreme Courts are sovereign. We can rule when we want in the cases which are brought to us by citizens and residents. In the EU, this openness of mind is increased by the fact we apply, in some cases, same norms from the EU treaties or the EU directives or regulations.
great initiative.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations. Global South Network provide a platform for meaningful dialogue and collaboration, fostering efforts to build a more equitable and resilient legal landscape.
GSN network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is, I believe, the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Ayad, for the immense work that you're doing in the GSN. The Global South Network is a much admired initiative.
كانت جزء لا يتجزأ من الدولة العثمانية.
We are being criticized for doing our job and for upholding the federal constitution. Like I have said in the past, I will not bend to such lame pressures and insinuations.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
Honourable judges, distinguished colleagues, on behalf of the Global South Network, it is my distinct honour to welcome you all to the second North-South Judicial Dialogue convened under our Global South Network Judges Guest Lecture Series. I am Dr. Nouman Riayat. I am a lecturer in law at the Leicester Law School, University of Leicester. Before this, I held academic roles at Cardiff University, the Institute of Law Jersey, the University of Law, and the University of York. I founded the Global South Network in March 2023, a unique initiative that brings together academics and practitioners beyond academia, amplify voices from and focused on the Global South, while fostering collaboration between the Global South and the Global North to address pressing social, political, economic, and legal challenges. As the founder and chief convener of the Global South Network, I previously organized around 150 knowledge exchange activities, including 4 international hybrid conferences, 107 PhD in progress weekly panel discussion seminars between May 2023 and September 2025, 12 guest lectures delivered by Supreme Court judges from different countries, and the first ever judicial dialogue between the Global North and the Global South involving Supreme Courts of 13 countries that took place on 20th of January 2025. The network made an unparalleled contribution to equality, diversity, and inclusion by hosting guest talks with judges from the Supreme Court of Ukraine during the Russia-Ukraine war, as well as both the Supreme Constitutional Court of Palestine and Supreme Court of Israel during the peak of the Middle East crisis. 70% of participants during the Global South Network activities since its launch in March 2023 were women. And we have built our bridges with our colleagues in Europe and beyond through dialogue such as today's. The achievements of the Global South Network lie not only in its events, but in its spirit. We amplify the voices of judges and scholars from regions often underrepresented in global legal discourse. We encourage comparative learning that is two-way rather than one-directional, and we demonstrate the Global South is not a passive recipient of ideas, but an active contributor to shaping global norms. Today's event is an embodiment of that mission by bringing together judges from Europe, Africa, Latin America under the framework of a North-South judicial dialogue. We show how administrative law can be enriched by perspectives that cross continents and legal traditions. We are honored to have with us distinguished judges who will offer initial reflections on just our chief guest, Honourable Justice Michail Pikramenos lecture. Justice Luis Alberto Alvarez Parra, President of the Council of State of Colombia, the Honourable Justice Kari, Kuusiniemi, President of the Supreme Administrative Court of Finland, Justice Yves Gounin from the Council of State of France, Honourable Justice Molemela, President of the Supreme Court of Appeal of South Africa, and Honourable Justice Professor Michail Smokovych, President of the Administrative Cassation Court of the Supreme Court of Ukraine. Your presence is testimony to the shared conviction that comparative judicial dialogue strengthens us all and that the Global South and the Global North have much to learn from one another. Today we are privileged to host Honourable Justice Michail Pikramenos, President of the Hellenic Council of State, the Supreme Administrative Court of Greece, since July 2024. Justice Michail Pikramenos serves as the President of the Council of State of Greece. His career at the Greek Council of State began in 1989 as an assistant judge, progressing to associate councillor in 1996, councillor in 2011, vice president in 2018. In addition to his judicial career, Mr. Pikramenos is a professor of public law at the Law Faculty of Aristotle University of Thessaloniki, where he also directs the postgraduate program in public law and political science. From 2013 to 2016, he served as Director General of the National School of Judiciary. Michail Pikramenos represented Greece at various international bodies, including the European Commission, for the efficiency of justice from 2011 to 2018, the European Judicial Training Network from 2013 to 2016, and the network of the Supreme Courts of the European Court of Human Rights from 2017 to 2018. Michail Pikramenos has also taught at the National School of Judiciary from 2001 to 2007 and the National School of Public Administration from 1994 to 1995. He has chaired or been a member of several legislative committees. His research and publications focus on constitutional and administrative law, the history of institutions, and the organization of the state and the justice system. With these words, it's my great honor to invite our guest speaker, Honourable Justice Michail Pikramenos, the President of the Hellenic Council of State of Greece, to deliver his lecture titled The Hellenic Council of State and its Position in the European Legal Order. Justice Pikramenos, the floor is yours.
Thank you very much. I would like to thank you for your invitation. It's an honor for me to speak about a very important issue. I would like also to thank Kari, the President of the Supreme Administrative Court of Finland. He's a very good friend, and we have cooperation, close cooperation in ACA. Thanks a lot, Honourable Justice Smokovych. I had the opportunity to meet him in Helsinki. Thank you very much, Honourable Justice Molemela. I hope that we shall have a very interesting discussion. Thank you also, Yves, Gounin, Conseiller d'État in France. He's a very good friend also, and we have a cooperation in ACA. Thank you also all the other colleagues who attend this session. The title of my presentation is the Hellenic Council of State and its position in the European legal order. I don't like the long presentations and the long speeches. It's very boring for the audience. So I will give you some ideas, some points, the basic points, and I think it's useful to have a dialogue. Dialogue is better than monologue. First, some elements for the Greek constitution. The constitution states that courts are to be divided into administrative, civil and criminal courts, organized on the basis of special laws. The Council of State and the ordinary administrative courts examine administrative disputes as the law specifies. Especially the Council of State has jurisdiction, among other things, which includes the annulment upon petition of enforceable acts of the administrative authorities and the appeals for the final judgments of ordinary administrative courts. The ordinary administrative courts have jurisdiction in substantive administrative disputes where the legislator reserves them for the Council of State, and categories of cases that come under the Council of State's jurisdiction for annulment. In the Constitution, we have three principles. The first is the principle of publicity, which covers both the hearing and publication of the judgment. The second principle is the principle of specific reasoning of judgments. And the third is the principle of mandatory publication of any dissenting opinion. Now, second point. the constitutional provisions for the integration of the country in Europe. The Article 28 of the Constitution provides the international convention, as of the time they are ratified by statute and become operative according to their respective conditions, shall be integral part of domestic Greek law and shall prevail over any contrary provision of the law. There is also an interpretative clause in the Article 28 that constitutes the foundation for the participation of the country in the European integration process. So, the Greek courts must proprio motu examine whether the provisions of domestic legislation are in conformity with the European law and interpret them in accordance with that. This is a main point for our courts. Third point, the influence of the Council of Europe and European Union in the judicial system in Greece. There are two levels. First, we shall tell some basic things about this influence for the judicial system. We have institutions of Council of Europe and European Union, and we have European initiatives and actions entail documents being drafted and prepared by special working groups on justice, which are then sent to the states to be taken into account in devising their own policies. One document of particular importance for the justice sector is the Magna Carta of European Judges, adopted by the General Assembly of the Consultative Council of European Judges, CCJE. The Magna Carta of Judges proclaims that the judiciary is one of the three branches of power in any democratic state. The document consists of 6 key sections covering the entire career of a judge, setting out the basic ways citizens can access justice and the need for transparency in the work of the courts. In Opinion 7 of 2.5 on Justice and Society, the CCJE highlighted the relationship between democracy and citizens receiving information on the organization of public authorities and the conditions in which the laws are drafted. In that broader context, it also included the importance of citizens knowing how judicial institutions function. The CCJE then went on to proclaim the need for courts to have procedures to provide citizens with information about their activities, to facilitate, among other things, the right of access to justice, such as periodic reports, service guidelines, web services, public information services. A critical role has been played in these developments in recent decades by the European Commission for the Efficiency of Justice, CEPEJ, which has published documents on the organization and efficiency of justice and has developed a strong network of experts from all member states of the Council of Europe and from European and non-European countries wishing to improve how their court system operates. In recent years, the EU has focused its attention on how the way in which court systems in its member states are organized and run interacts with the level of economic and social development in those countries. To that end, it has begun publishing an annual report entitled the EU's Justice Scoreboard, which includes data on the performance of member state court. As you understand, all those activities have a very strong influence in the judicial system in Greece. For example, judicial maps. For example, management of the courts for the presidents, for the judges in individual level. Fourth point. The interpretation of the Constitution in the light of the European Union law and the European Convention of Human Rights. The national constitution in modern times does not play an autonomous role and is not the sole protagonist in shaping the social, economic, and political life of the countries of Europe. Membership of the European Union and the Council of Europe has decisive influence on national legal orders and obliges the courts of the member states, especially the highest courts, to develop methods and techniques for interpreting the Constitution in the light of the treaties of the European Union and the Rome Convention. The combined interpretation of national constitutional rules and European rules has advantages and disadvantages. If we compare advantages and disadvantages, the balance, according to my view, is the favor of the advantages. This is because the case law of the Court of Justice of the European Union and the Strasbourg Court has been instrumental in modernizing the national approach to important issues in the field of rights, especially in the field of rights. I will give you 3 examples from the Greek jurisprudence. First, the Article 14, paragraph 9 of the Constitution has absolute prohibition for the owners, partners, shareholders, or managing director of an information media to be in the same time owner, partner, major shareholder, managing director of an enterprise that undertakes towards the public administration or towards a legal entity of the wider public sector to perform works or to supply goods or services. Absolute prohibition for these owners. The Grand Chamber of the Court of European Union, in case C-213 of 2007, held that we have to interpret our constitution under the light of the community law. So the court held that there is a violation of the European law to have an absolute prohibition for the activities of these persons. And after that judgment, the Council of State proceeded to a new interpretation of this absolute prohibition, this constitutional provision, in the light of EU law, and held that the prohibition is not absolute despite the letter of the provision, but relative. Second example, in the case of Lykourezos versus Greece, the European Court of Human Rights held that by considering the applicant's election under the new Article 57 of the Constitution, without taking into account that he had been, the applicant, elected in 2000 in full accordance with the law, the special Supreme Court, our court, was wrong, in very simple words, because this situation creates a violation of the Article 3 of the protocol, because there is an absolute prohibition for the persons who want to be members of the parliament and they work in the same time as lawyers. And the problem was that the constitution didn't have a period, a transition for this new article in the Greek constitution. So there has been a violation of the provision of the protocol. Third example from the Court of Luxembourg. According to the Greek constitution, there are absolute prohibitions for the duration of private law employment relationships in the public administration. According to the letter of the constitution, conversion by legislation of staff covered by the first section to permanent civil servants or conversion of their contracts into contracts of indefinite duration is prohibited. Another absolute prohibition in the field of working in public administration. So the contract cannot transform for indefinite duration. We have all, in this case, a judgment from the Court of Luxembourg, and says that this constitutional provision is violation of the EU law because we have an absolute prohibition for this transformation. Three examples for the relation between the national constitution and the EU law and the Rome Convention. Fifth point, the national legislature and the Council of State under the beneficial influence of the case law of the Convention of Rome. A review of the relationship between the case law of the Council of State and the European Court of Human Rights would lead to the observation that from 1953, the year in which the Convention entered the Greek legal order, until approximately 90s, the Greek court always considered that the right guaranteed by the Rome Convention was of lesser or equal with the right guaranteed by the Greek constitution. And in contrast to the extremely fruitful exercise of judicial power by the Council of State in substantive administrative law from 1929 until 70s, and the particularly creative interpretation of constitution provisions under the Constitution of 1975. Second point, trial. What is trial? Is the institution by which the application of the rules of law in social life is ensured and consists of a set of legally regulated actions by judicial bodies and parties which aim at an authentic diagnosis of the true legal situation. The trial serves several levels. The first purpose of the trial is to protect the rights of any subject of law who is impeded in the exercise of his right. The next objective is legal certainty, which operates at two levels: at the level of the specific dispute with its final resolution. At the second level, the existence of litigation as an institution consolidates society's confidence in the application of the rules of law and enhances the sense of security experienced by citizens within the legal order. According to the Court of Strasbourg, the core of the right of access consists in submitting a claim to a court which has jurisdiction and competence to examine its legal and factual basis and to reach a binding decision disposing of the dispute. So, in this area, in the area of access to the court, we have also the beneficial influence of the Convention of the Court of Strasbourg. And there are some examples, and I don't want to give you details what examples are, what make us change our view for the access to the court. Another very important element of Strasbourg Convention is the reasonable duration of proceedings. We have a series of condemnations about violated this special right, underlining the importance that the Convention attaches to the general principle of the proper administration of justice without delays that undermine its effectiveness and credibility and ultimately lead to phenomena of denial of justice. To this end, the Convention has ruled that states must organize their judicial system in order to achieve the major objective of administering justice with a reasonable time. The issue of the violation of the right to a reasonable length of trial has been addressed by the Convention in a number of Greek cases, and a large number of convictions have been issued finding excessive length of trial. This problem occurred with particular intensity in administrative justice, but it also exists in civil and criminal justice. The Strasbourg Court launched a pilot judgment procedure starting with an administrative trial with a judgment in Athanasiou versus Greeks. The court noted in that judgment that significant and recurrent delays in the administration of justice are a particularly worrying phenomenon which may be of particular concern to the court. Following the above-mentioned judgment, the Greek state enacted the provisions of a law which introduced as a new remedy the application for just satisfaction for exceeding the reasonable duration of administrative proceedings which is brought by each party and is directed against the Greek state. Court of Strasbourg examined in the case Techniki Olympiaki versus Greece judgment the effectiveness of the action for damages within the meaning of Article 35. In general terms, the court held that the system is effective. There are safeguards for the effectiveness of the system. I will finish this short presentation saying that the European Network of Councils for the Judiciary in the report 2017-2018, Public Confidence and the Image of Justice, notes that public confidence is vital for the independence of the nation's judiciary. According to the report, public trust in the European judiciaries varies significantly from country to country. However, the level of trust cannot be viewed as distinct from the general differences between high trust societies, mainly in the northwest of Europe, and low trust societies, mainly in the south and east. Historical, social, and economic reasons account for these differences. Trust is the bedrock of any successful operation, whether it be private or state. The judiciary is not in competition with other branches of power, but it is fundamental that trust is established and there is a recognition of its independence in the way of it functions. Some first conclusions. There are always judgments from both the European countries that they give us the opportunity to modernize our state, to modernize our courts and judicial system. We earn a lot. It's very difficult to have very fast results. But I think that we have the opportunity to improve our state, to improve our judiciary. I think that the European principles, the European laws, the European principles and the European Charter of Magna Carta, and all the work of the experts in Europe is very useful for us, and we have to work as legislator, because in many cases we need the legislator, but also in good practices. I believe that the rules, the law, is the beginning, but the most important is the implementation of the law. And I think that this is a very difficult field, how to implement laws that they want to change the views of people who live with stereotypes and with traditional attitudes. Thank you.
Thank you very much, Honourable Justice Michail Pikramenos, President of Supreme Administrative Court, the Hellenic Councilofstate of Greece, for a very insightful presentation, which clearly offers many insight to courts outside the Europe. I now open the floor to the discussion from judges of the Supreme Courts of other countries. The next speaker is going to deliver the response in Spanish. Simultaneously, the English version will be shared with you through slides. Having this said, allow me to invite Honourable Justice Luis Alberto Alvarez Parra, President of the Council of State, Supreme Administrative Court of Colombia.
Buenos días en Colombia. Buenas tardes. Quiero expresar mi sincero agradecimiento al doctor Naomen Riaet, fundador y coordinador de la Red del Sur Global, por su visión y compromiso en la creación de esta plataforma inclusiva, diversa e invaluable para el diálogo entre los poderes judiciales de todo el mundo. Es un honor poder saludar a todos ustedes y en relación con la conferencia dictada por el magistrado Michail Pikramenos, presidente del Consejo de Estado Helénico de Grecia, subrayar una idea básicamente en estos breves 5 minutos que me han concedido y también subrayar algunas ideas en torno del Consejo de Estado colombiano. Entiendo que el Consejo de Estado helénico, como Tribunal Supremo Administrativo de Grecia, hemos advertido, tiene a su cargo también la función de resolver disputas administrativas complejas y al mismo tiempo armonizar el derecho administrativo nacional con el marco más amplio de derecho de la Unión Europea, de la jurisprudencia del Tribunal Europeo de Justicia y del Tribunal Europeo de Derechos Humanos. Esta doble responsabilidad pone de relieve el papel fundamental que desempeña este órgano de justicia administrativa en Grecia a la hora de garantizar que el derecho interno funcione en sintonía con las normas jurídicas supranacionales, salvaguardando así los ordenamientos jurídicos tanto nacional como europeo. Por nuestra parte, el Consejo de Estado de Colombia es un órgano que pertenece a la rama judicial. Tiene un sistema dual de jurisdicción, esto es, existe una jurisdicción ordinaria encargada de los asuntos civiles, laborales, comerciales, y una jurisdicción especializada en cabeza del Consejo de Estado de Colombia. Esta es una jurisdicción que lleva 200 años en nuestro país. En su origen, su función inicial fue la de ser un órgano consultivo del gobierno. Hasta la Constitución de 1886 se le entregó la función de ser juez de la administración y solo hasta 1930 se organizó esta jurisdicción en Colombia a través de la ley 130. Hoy el Consejo de Estado, con la Constitución del 91, tiene las dos funciones. Hace la función de Tribunal Supremo de lo Contencioso Administrativo, que tiene a su cargo las decisiones relacionadas con las controversias de gran relevancia generadas por actos, hechos, omisiones, contratos, donde intervienen entidades públicas, y de otra parte la función consultiva. Si quisiéramos subrayar una idea de nuestro Consejo de Estado hoy, tenemos que señalar que es el Consejo de Estado un órgano que desarrolla una función de control fundamental al Estado de Derecho y el respeto de la legalidad de nuestro país. La función jurisdiccional la viene cumpliendo esta sala de consulta y tiene unas funciones muy importantes, no solamente de resolver las consultas de los departamentos administrativos y los ministerios o del gobierno, sino que además tiene una función colegisladora, esto es, de proponer proyectos de ley o proyectos de reforma constitucional. Finalmente, quisiera señalar que este Consejo de Estado tiene una función que viene cumpliendo respecto del conflicto armado. Aquí en Colombia, por la violencia, se han generado unas grandes condenas al Estado históricamente por los daños causados al país y a la sociedad en general. Somos un Consejo de Estado que cumple la función de ser juez de la administración y hoy constituye un baluarte fundamental de la democracia colombiana. Gracias.
Thank you, Honourable Justice Luis Alberto Alvarez, for your comments. Now, allow me to invite our second discussant, Honourable Justice Moebi Betty Molemela, President of the Supreme Court of Appeal of South Africa, to share their comments.
Thank you very much, Honourable Chair, for giving me the floor. I want to extend my heartfelt appreciation to Dr. Norman Riat, the founder and convener of the Global South Network, for inviting me to participate in this critical dialogue. His visionary leadership has established a vibrant forum where judges, academics, and practitioners from around the world can share and exchange ideas. I would also like to express my sincere gratitude to the Honourable President of the Hellenic Council of State, Justice Michail Pikramenos, for his insightful lecture on the Hellenic Council of State and its role in the European legal order. His reflections underscore the importance of administrative courts in safeguarding the rule of law while balancing national and supranational obligations. I can say without fear of contradiction that these insights are both valuable and thought-provoking for the legal community in South Africa and probably across the Global South. The Hellenic Council of State operates within a distinctly European context where national administrative law must align with European Union law and the jurisprudence of both the European Court of Justice and the European Court of Human Rights. In contrast, some courts outside the European Union, such as the South African Supreme Court of Appeal, operate differently. In South Africa, our administrative law is primarily anchored in Section 33 of our Constitution. The Promotion of Administrative Justice Act 3 of 2000, commonly referred to as PAJA, was enacted to give effect to the constitutional right to just administrative action. While foreign authorities may have persuasive value, our ultimate responsibility as South African judges is to interpret administrative justice within the framework of South Africa's constitutional order. With that said, Section 39 of the Constitution clearly provides that the courts must consider international law. So that is obligatory. The exercise of public power must be lawful and reasonable, and all processes followed to reach a decision must be fair. This is how public officials are held accountable. Another notable difference lies in institutional design. While the Hellenic Council of State serves as Greece's Supreme Administrative Court, the Supreme Court of Appeal of South Africa is not the final arbiter in administrative law disputes. It functions as the penultimate appellate court of general jurisdiction. According to Section 16 and 17 of the Superior Courts Act 10 of 2013, only complex appeals should be heard by the Supreme Court of Appeal of South Africa. Thus, the judgments of the Supreme Court of Appeal often represent the first significant appellate consideration of complex legal issues, including those related to administrative law. However, it is the Constitutional Court that, as the apex court, holds ultimate authority on all matters. The Constitutional Court frequently builds upon or affirms the reasoning of the Supreme Court of Appeal, emphasizing the latter's foundational role in shaping administrative law jurisprudence. Considering that until 2013, the Supreme Court was the apex court in respect of all legal disputes, barring cases in which constitutional issues were raised, the Supreme Court of Appeal has played a significant interpretive role in determining whether a decision constitutes administrative action subject to judicial review. There are two judgments that you can consider. The one is Grace Marine Hout Bay, Pty Ltd and others versus Minister of Public Works. It's a 2005 judgment of the Supreme Court of Appeal. There is also a judgment of in the matter Democratic Alliance versus President of South Africa. It's a 2012 judgment where the issue at hand was the rationality of executive decisions concerning administrative appointments, specifically regarding the appointment of the National Director of Public Prosecutions. The Constitutional Court confirmed that even the most senior executive actions must meet the constitutional standard of rationality, a principle that protects against arbitrary decisions. As I conclude, having observed the broader landscape, I am struck by how themes from various jurisdictions resonate globally. It is evident that in legal disputes involving administrative issues across Europe, Asia, Latin America, and Africa, courts encounter remarkably similar challenges. These challenges extend beyond geography, legal cultures, and institutional designs, emphasizing the need for international cooperation among supreme administrative courts worldwide. Initiatives like today's dialogue allow us to compare jurisprudence, share best practices, and develop common principles. This has the potential to contribute to transnational standards in procedure and enhance administrative law globally. Ultimately, the pursuit of justice is a shared endeavor. I thank you.
Thank you, Honourable Justice Mobe Betty Molemela, President of the Supreme Court of Appeal of South Africa, for your wonderful contribution. Now, I would like to invite Honourable Justice Kari Kuusiniemi, President of the Supreme Administrative Court of Finland, to share their comments. Over to you, Honourable Justice Kari.
Thank you so much, Chair. It's a great pleasure and honor to take the floor in today's important event. Allow me to begin by paying tribute to Dr. Norman Rayat, who is the founder of the Global South Network. And I can only echo what the preceding speaker, President Molemela, was saying. But I would like to point out that Dr. Rayat's initiatives have not only enriched comparative judicial dialogue, but have also fostered mutual understanding of the diverse challenges that courts face in safeguarding the rule of law and constitutionalism. In these days of backsliding of the rule of law, rising authoritarianism, and polarization, it is of utmost importance to strengthen mutual understanding and trust. But obviously, I also wish to extend my deep appreciation to my distinguished colleague and dear friend, Honourable President of the Hellenic Council of State, Michail Pikramenos, for his insightful and thought-provoking lecture. But first things first, Michail, my friend, I want to congratulate you on behalf of the bronze medal in the basketball European Championships, where Greece crushed the Finnish team called Wolfpack. I'm trying to recover about that. And the reflections of Michail on the interaction between national administrative law and jurisprudence of the European courts illuminate how administrative courts in Europe must navigate an increasingly complex legal environment while upholding both national traditions and supranational obligations. From the perspective of the Supreme Administrative Court of Finland, there are many parallels in our judicial responsibilities, no wonder. Like the Greek Supreme Administrative Court, we operate as the final authority in administrative law disputes, ensuring legality in governance, protecting fundamental rights, and guiding legal development through precedent. The challenges we face, from environmental protection and climate policy to immigration, taxation, and social welfare, often require balancing national decision-making with compliance under European Union law and international human rights obligations. Despite these similarities, important differences exist in the scope and nature of their powers. The Council of State of Greece primarily hears petitions for judicial review, annulment of administrative acts for excess of power, deciding in first and last instance. Some categories of such cases, due to their nature or importance, fall under the jurisdiction of administrative courts. Ordinary administrative courts also exercise full jurisdiction in the first instance, while the Council of State reviews their final judgments. But on the other side, the Supreme Administrative Court of Finland, which was established 170 years ago in 1918, is the highest court for administrative cases in Finland, while the Supreme Court handles civil and criminal matters. So we have two parallel court lines, just like in Greece, but unlike in South Africa, for instance. The court's mission is to provide judicial protection and guide the application of law through precedent. It serves exclusively as the judicial body, with its primary mission being a provision of judicial protection and interpretation of administrative law. But even if it's not a Council of State after the model of, for instance, France, which we'll certainly hear more closely in a moment, my court also delivers opinions concerning draft legislation and may also, under the Constitution, submit initiatives to government to amend legislation, obviously in practice with regard to enhancing legal protection, safeguarding of the rule of law, and developing administrative procedure. In the court, cases require almost exclusively leave to appeal, and they are handled in writing. But the court may also hold oral hearings and on-site inspections, for instance, in environmental cases. The court receives and decides about 4,000 cases annually, mainly concerning immigration, taxation, social welfare, environment and land use, as well as regional and municipal administration. Its decisions are final. The court is composed of the president, 22 justices, and supported by some 90 staff members, including referendaries, who are presenting the cases and writing their judicial assessment in their very profound memos. The system of leave to appeal reflects Finland's emphasis on judicial efficiency and accessibility. Linking to President Pikramenos' emphasis on EU and international human rights law, it's important to mention a couple of examples of rulings of the Supreme Administrative Court of Finland. I will mention two recent climate cases. By the way, these cases or other judgments can be found on our web pages in English translations. So the first one, which was decided in 2023, the appellants, two nationwide NGOs, challenged the Finnish government's annual climate report, arguing that it failed to include the required assessment of additional measures needed to achieve climate targets, despite evidence of collapsing carbon sinks. They claimed that the omission violated the National Climate Act and demanded that the government's decision be repealed and returned for further preparation. However, the court dismissed the appeal, ruling that submitting the annual climate report to Parliament was not an administrative decision subject to appeal. The court noted it could only intervene if the government's inaction or refusal to take necessary measures clearly violated the Climate Act or demonstrated disregard of its international obligations, that is the Paris Agreement for first and foremost. In this case, however, the court found no evidence of such neglect and held the government's action was not an appealable administrative decision. But in 2025, in the second climate litigation, the assessment of admissibility changed, mostly because of the effect of the European Court of Human Rights Grand Chamber judgment in the notorious case Kliima Seniorinen. Even if Finnish government's annual climate report to Parliament under the Climate Act was not appealable, as only decisions amending climate policy plans could be challenged. The Supreme Administrative Court interpreted the appealability extensively, referring to the case Klima Seniorinen, and decided to examine the appeals. However, the court emphasized that the government holds primary responsibility for climate policy in line with national and international obligations, while the court's role is to ensure decisions comply with the law and protect fundamental rights. Although climate change poses serious human rights risks, the court held that finding the government in violation for inaction requires a high threshold given the constitutional separation of powers and the complexity of climate policy decisions. It goes without saying that we have tens or hundreds of cases where EU law and human rights law is tackled, but to save time, I will not go into those decisions or judgments in more detail. But as a kind of a summary, I would say that the Supreme Administrative Court not only ensures judicial protection domestically, but also actively contributes to the international exchange of judicial practices. The court engages in both regional and global cooperation with supreme administrative jurisdictions. I might mention the acronym ACA Europe, which was already at the outset mentioned by President Pikramenos. That's the Association of Councils of State and Supreme Administrative Jurisdictions in the European Union. That's a very, very important platform, and I'm happy to tell you that President Pikramenos has taken over the presidency from me to the next 2 years, and I wish him and the court the best of success. To conclude, it is in this shared space facilitated by the Global South Network that international cooperation among Supreme Administrative Courts becomes indispensable. Exchanges such as today's dialogue allow us to learn from each other's experiences in adjudication complex issues of public administration, human rights, and regulatory governance. The network plays a particularly important role by connecting European and non-European jurisdictions, which today's event is a paramount example. In this sense, the network under active leadership of Dr. Riyad is not only fostering dialogue, but also building bridges between courts, traditions, and continents. It is my sincere hope that these bridges will continue to strengthen, enabling us to work together in advancing the rule of law, judicial independence, and good governance worldwide. Thank you so much for your attention.
Thank you, Honourable Justice Kari Kuusiniemi, President of the Supreme Administrative Court of Finland, for your insightful contribution. Indeed, we are, as a network, committed to all these values which you just mentioned. Now, I would like to invite our next discussant, Honourable Justice Professor Michail Smokovych, President of the Administrative Cassation Court, the Supreme Court of Ukraine, who is going to share their comments in Ukrainian language, and I'm going to display the English version through PowerPoint slides for our English audience.
Good afternoon. Вельми шановний засновнику та головний організатори глобальної мережі Півдня, докторе Науман Реядят, вельми шановний голово Державної ради Греції, пане Михаїле Пікраменос, вельми шановний голово Вищого адміністративного суду Фінляндії Карі Kuusiniemi, шановні учасники, щиро вітаю кожного з вас, дорогі колеги. на важливій лекції для суддів глобальної південної мережі. Вдячний за запрошення та організацію онлайн-заходу. Стратегічний курс України на інтеграцію до європейського правового простору зумовлює системне наближення національного законодавства до права Європейського Союзу. Це засвідчує прагнення України стати повноцінним суб'єктом європейської правової спільноти та зміцнити власну ідентичність як демократичної та правової держави. Верховний суд – найвищий суд у системі судоустрою держави, як і в інших європейських юрисдикціях. Верховний суд забезпечує сталість та єдність судової практики у порядку та спосіб визначення процесуальним законом. Верховний суд відіграє визначальну роль в утвердженні верховенства права та інтеграції національної судової системи у європейський і міжнародний правопорядок. Повномасштабна агресія проти України поставила перед Верховним судом безпрецедентні виклики серед головних аспектів забезпечення безперервності правосуддя, яке є практичним інструментом реалізації конституційного права кожного на судовий захист, гарантованого статтею 55 Конституції України. Навіть у умовах воєнного стану, коли можуть обмежуватися окремі права і свободи громадян, право на судовий захист залишається непорушним. Це зумовлює необхідність забезпечення належного та безперервного функціонування судової системи як запоруки верховенства права та демократичних засад державного устрою. Безперервність правосуддя в умовах війни проявляється, зокрема, через забезпечення доступу до правосуддя, яке має першочергове значення. Цифровізацію процесів, що дозволяє здійснювати судочинство в умовах правового режиму воєнного стану. У демократичному суспільстві надзвичайно важливо забезпечити баланс між національною безпекою і правами людини, особливо в умовах воєнних реалій. Верховний суд відіграє ключову роль у формуванні важливих правових позицій, забезпечуючи єдність судової практики, юридичну визначеність та передбачуваність правозастосування. Правові позиції Верховного суду сприяють однаковому тлумаченню норм законодавства судами нижчих інстанцій і слугують правовим орієнтиром для учасників правовідносин. У період дії воєнного стану Верховний суд своїми правовими позиціями заклав доктринальні положення щодо гарантування прав військовослужбовців, ветеранів війни, внутрішньо переміщених та інших категорій громадян, що постраждали внаслідок агресії, забезпечуючи реалізацію принципів справедливості, юридичної визначеності та пропорційності. Практика Європейського суду з прав людини та Суду справедливості Європейського Союзу відіграє дедалі важливу роль у розвитку національної правової системи. Суд застосовує принцип верховенства права з урахуванням судової практики Європейського суду з прав людини. Суди застосовують при розгляді справ конвенцію та практику ЄСПЛ як джерело права. Рішення Європейського суду з прав людини є обов'язковими для врахування українськими судами та фактично становлять джерело права, сприяючи зміцненню верховенства права, захисту прав людини та єдності судової практики. Крім того, встановлення міжнародною судовою установою, юрисдикція якої визнана Україною, порушення Україною міжнародних зобов'язань при вирішенні цієї справи судом є підставою для перегляду судових рішень в зв'язку з виключними обставинами. Практика суду справедливості Європейського Союзу слугує міцним орієнтиром у процесі гармонізації національного законодавства з правом ЄС, що особливо актуально в контексті виконання угоди про асоціації та прагнення України до повноцінного членства в Європейському Союзі. Задля забезпечення єдиного підходу щодо застосування під час розв'язання публічно-правових спорів практики суду справедливості ЄС Ще у 2014 році Вищий адміністративний суд України в інформаційному листі від 18 листопада 2014 року зазначив, зокрема, що враховуючи європейський напрямок розвитку України, а також набуття чинності угодою про асоціацію, правові позиції, сформульовані в рішеннях Суду Європейського Союзу, можуть враховуватися судами як аргументація, міркування стосовно гармонійного тлумачення національного законодавства України згідно з усталеними стандартами правової системи Євросоюзу. Таким чином, інтеграція європейської судової практики в сфері національного права є необхідною умовою для побудови справедливої, ефективної та європейсько орієнтованої системи правосуддя України. Напрями співпраці між Верховними судами світу необхідно посилити між Верховними судами різних держав, і це є важливим чинником розвитку верховенства прав. Напрямами такої співпраці можуть бути участь у міжнародних асоціаціях, наприклад, АКА Європа та інші, інституційне партнерство між Верховними судами з метою розроблення уніфікованих правових підходів до захисту прав людини, обмін судовою практикою, взаємне використання прецедентів та правових позицій, що сприяє конвергенції правових систем, спільні науково-практичні конференції та колоквіуми, де обговорюються сучасні виклики, співпраця, яка закріплює тривалі механізми комунікації, стажування суддів та працівників апарату судів, обмін фахівцями тощо. Зауважу, що упродовж збройної агресії Російської Федерації проведення міжнародних наукових і професійних заходів в Україні залишаються ускладненими. І ми щиро сподіваємося, що після перемоги України такі професійні зустрічі зможуть відбуватися на українській незалежній землі, утверджуючи єдність правничої родини та неперервність професійного діалогу Верховних судів світу. Верховний суд посідає важливе місце в формуванні європейського та міжнародного правопорядку, одночасно забезпечуючи безперервність правосуддя в умовах війни. Імплементація європейських стандартів у сферу національного права є ключовим чинником для формування ефективної та інтегрованої в європейський правовий простір судової системи. Розширення співпраці з Верховними судами світу сприятиме лише обміну досвідом у сфері застосування міжнародних стандартів, уніфікації правових підходів та розвитку судових доктрин. Така взаємодія забезпечить знаходження оптимальних правових механізмів та інноваційних шляхів захисту прав людини, що відповідають сучасним викликам. Переконаний, що завдяки міжнародній співпраці та транснаціональному діалогу ми усі разом зможемо напрацювати найкращі практики та сформувати єдині стандарти судочинства задля ефективного захисту прав людини на засадах верховенства права. Дякую за слово, вдячний за організацію заходу. Thank you very much.
Thank you, Honourable Justice Professor Michail Smokovych, President of the Administrative Cassation Court, Supreme Court of Ukraine, for delivering your insightful comments. Now I invite Honourable Justice Yves Gounin from the Council of State, France. Over to you.
Thank you very much, Mr. Chair, dear colleagues, dear participants. I will be short first because I'm the last one to speak after a long list of speakers, and second, I am the most humble of those speakers speaking after those prestigious Chief Justices, and as you noticed, I'm not the Chief Justice. My esteemed colleague and friend, Chief Justice Pikramenos, has just introduced us in a very enlightening way to the Hellenic State Council. The French State Council is very similar to its Greek counterparts, and I would like to emphasize two of its main characteristics. One, the French State Council is a Supreme Court. This might sound quite exotic to our listeners, especially in the Anglo-Saxon world, in the US, the UK, or in South Africa, Madam Chief Justice, as there is only one Supreme Court in those places. In Greece, in France, and in other countries like Finland or Colombia, Mr. President, there is not one Supreme Court, but two. On the one hand, the ordinary Supreme Court deals with civil cases, criminal cases, commercial cases, and so on. And there is one specific Supreme Court, the Administrative Supreme Court, which is competent for any cases in which the state or any public entity is involved, because the state and the public entities, they have special duties, they have special rights, they are not common litigants. Two, the State Council is not only a court. The State Council, as its name says, the State Council counsels the state. It gives the state, it gives some advice to the states. This is the historical legacy of the King's Council in the Middle Ages in France. The King's Council was made of knights and peers and legal experts who whispered at the ear of a sovereign. This rule went on throughout history, and the French State Council was created right after the French Revolution by Napoleon Bonaparte in 1799. It aimed to go on with this fundamental principle of giving the sovereign, which is not a king nowadays, but the Prime Minister, the President of the Republic, some legal advice. Those two characteristics, as I said, are quite exotic, are quite atypical for some of our listeners from the Anglo-Saxon world. But I want to say that it is not a specificity of some rare, marginalized, exotic countries such as Greece or Colombia or France. This model, this pattern, if I may say, of a state council with both duality of jurisdiction on the one hand and duality of functions on the other hand, they exist all over the world. As a matter of fact, they exist in Europe, in Greece, in France, in Italy, in the Netherlands, Belgium, Luxembourg, and so on. And it exists outside of Europe, for example, in Egypt, in Turkey, in Algeria, in Colombia, in Thailand. So thank you very, very much, Professor Rayat, for having given us and my esteemed colleagues the opportunity to introduce to you to such an exotic institution. Thank you.
Thank you very much, Honourable Justice Yves Gounin, for your wonderful contribution. Now I would like to invite our Honourable Chief Guest, Justice Michail Pikramenos, President of the Supreme Administrative Court of Greece, to respond to these comments, or if there is any questions or remarks you would like to offer.
Yes, I would like to add that among the competences of the Greek Council of State is the consultative competence for the drafts of residential decrees, not all the law. I would like also to add that last 100 years, the Council of State plays a very important role because many judges help the government in legislatory reforms, participating legislatory committees, disciplinary committees, other organs of the state. We have many supplementary competences helping the functions of state. We don't have only judicial role as a body, but as individual judges, we work with the state ministries and other public organs. And I think it's very useful to have specialized lawyers like judges of our court who have studied in Europe, in North America. I think that the level, especially of the judges of Council of State, is higher in Greece than the other branches. And I think that we can bring new ideas for law science in Greece. We had also law professors from the Council of State. Two presidents of Republic came from our court, Michail, who was a professor in law, and now Mrs. Sakararopoulou, the ex-president of the Republic. I would like also to add contribution of our institution is not only a judicial, like in France. I think in France, the French model is broader than our brother. I know that the judges work periodically in the administration.
Thank you, Honourable Justice Michail Pikramenos, President of the Supreme Administrative Court of Greece, for your responses and comments to discussion by the Honourable Judges of Supreme Administrative Courts across the world. Now I would like to open the floor to question and answer session. So I invited all for this event to submit their questions in advance or during the session if there's any comment, any questions I have received. But before reading out that question, I would like to invite the discussant if there is any question. First question I received: how do you see the nature and the scope of relationship between the Supreme Administrative Court of Greece and these supranational courts? Is it one of the conflict, or is it cooperation, or is it a combination of both?
The academics have written a lot about the supremacy of European law, the relation between constitution and European law. I must say that judges are scientists, but at the same time are practitioners. So without great theoretical schemes, we try to co-interpret the co-interpretation of the rules and to implement the rules as a whole, as a body. This is our difference from the academics. We can find good solutions without great words, great phrases, but steps in our text of judicial decision which help the country in Europe. So in real terms, we have faced this problem without theoretical schemes.
Thank you very much. Second question, and I think that second question is for all panelists. Some of the organization associations were highlighted in comments and the discussion of some of the respondents. And the question is, so what's the nature and the scope of cooperation among different courts? How do you see that? Is it something successful, or are there any challenges facing this cooperation? And what are the objectives, if it is successful, we are going to achieve? So I will start with the Honourable Chief Guest, and then I will go to Justice Yves Gounin and then Justice Kari Kuusiniemi, who have already raised their hands. Any comments from you, Justice Michail Pikramenos? In that case, I would go to Justice Yves Gounin. Over to you.
Thank you, Mr. Chair. This is quite an interesting question, and I want to emphasize maybe two aspects. When it comes to international cooperation, there are two frameworks. One is that we work together because we have to do something together, because we are compelled to do something together, because the international community expects us to do something together, because the international standards of the law imposed to us to do something. This is not the case of Supreme Courts. Supreme Courts are sovereign. I will come later to the specific case of the EU. Supreme Courts are sovereign, and we can rule the way we want on the cases which are brought to us by citizens and residents in our own countries. But it's very interesting to know what the neighbor is doing in a similar case. So, good sense and reason impose to us, with our open mind, to go and ask to our German, Spanish, Italian, Greek, Finnish neighbor, oh, you have had the same case, and how did you rule on this case? In the EU, this openness of mind is increased by the fact that we apply, in some cases, the same norms from the EU treaties or the EU directives or regulations. So the fact that we are members of the EU is even stronger impetus for this discussion. Thank you.
Thank you, Honourable Justice Yves Gounin, Council of State of France, for your reply. Now I would like to go to Justice Kari, Kuusiniemi, President of the Supreme Administrative Court of Finland.
Thank you, Chair. My friend Yves said very much the same things what I wanted to say. I'm trying to then take a little bit different approach, starting from a cooperation within the ACA Europe, which was already mentioned. So I think, as just like Yves put it, we apply the same legislation, more or less. So I would claim that our cooperation is very successful and goes right to the point. So the more closely you share the same provisions of law, same principles and so on, the more fruitful the cooperation is. And then the cooperation of European Union countries with the the European courts. It's a kind of dialogue, for instance, between the EU Court of Justice, dialogue starting with reference of preliminary ruling. So we discuss with the court and they answer something and we decide in our judgment something. And it's also a way to develop EU law and its interpretation. And with regard to the Strasbourg court, I already mentioned in my comment the Klima Seniorinen case, which was clearly the basis of our changed national interpretation of law. So we put high regard on the assessment of the Human Rights Court and decided that we have to interpret our national norms much more extensively than would have been the case otherwise. And my last two comments are about the Nordic cooperation. We have a very close cooperation between the 5 Nordic countries, which can be based on very similar cultural and historical and societal background. So it's all really straightforward and fruitful. And last comment, we have also established bilateral relations. For instance, tomorrow we will receive the President, Vice President, Justices from the Constitutional Court of Slovenia. Finland has no constitutional court, but we have the same issues. We apply the same EU law. We have same constitutional principles applied from different angles, but we have found it's very interesting and important. Thank you.
Thank you, Honourable Justice Kari Kuusiniemi, President, Supreme Administrative Court of Finland, for your reply. I think Honourable Chief Guest wants to respond. So over to you, Honourable Justice Michail Pikramenos.
Yes, I would like to notice that our relation with the other European Supreme Courts exists in our daily work. For example, the rapporteur judge, when she prepares a case, always read the jurisprudence of French, Conseil d'État, German court, of Italian court. We need this information. And during the meetings, we always talk about the other European administrative Supreme Courts. And we feel more comfortable. The work of a good judge is connected with his or her ability to give information from the other European court. This is very important for our court. And this is, I think, our difference from other courts in Greece. And we have daily dialogue with this way. And we have in our decisions references to Conseil d'État, to German Supreme Court, to USA Supreme Court, and we feel lucky because we live in the Western world. And if we compare Western Europe and North America, I feel that we have a lot of ideas and principles, and we have a dialogue in a democratic framework. This is a value, and we must hold these values.
Thank you, Honourable Chief Guest, Justice Michail Pikramenos, President of the Hellenic Council of State of Greece, for your reply to the question. I have one final question, but that is with regard to the last slide of Honourable President of the Supreme Constitutional Court of the Ukraine Supreme Court, Justice Michail Smokovych. What are the specific challenges that the court is facing while operating and functioning in a context shaped by the war with neighbors?
The war gave birth to a lot of challenges in the work of the Administrative Cassation Court.
Найбільші виклики – це зв'язок із учасниками у справах.
The greatest challenge concerns the connection with the participants of the cases.
І повідомлення, і збереження їх процесуальних та інших прав під час розгляду справ.
And preserving of their procedural rights during the consideration of the noted cases.
Не дивлячись на те, що російські війська були біля Києва,
despite the fact that Russian armed forces have been near Kyiv,
Касаційний суд не переставав здійснювати судочинство і працювати.
The Cassation Court did not stop its operation concerning judicial proceedings and continued its work.
У зв'язку з військовим станом виникло дуже багато справ у сфері публічних відносин.
A lot of cases concerning the public relations appeared because of the martial law.
І основне завдання Касаційно-адміністративного суду – забезпечення єдності судової практики було непростим.
And one of the main tasks of the Cassation Court ensuring the uniformity of case law was not easy.
І не дивлячись на окупації певних територій, усі адміністративні суди системи адміністративних судів України працюють, крім Херсонського окружного адміністративного суду.
Despite the occupation of certain territories, all courts of administrative jurisdiction function except for the administrative court of Kherson Oblast or region.
Шляхом постійного діалогу із суддями всіх інстанцій адміністративних судів, при допомозі цифровізації, при допомозі конференц-зв'язку,
by means of permanent dialogue and communication with judges of all instances of administrative court with the use of digitalization and video conference connection.
Нам вдається забезпечити єдність судової практики при розв'язанні нових спорів у сфері публічно-правових відносин.
We managed to ensure the uniformity of case law while considering new cases in the ensuring of public dialogue.
Крім того, ми дуже тісно співпрацюємо із Європейським судом з прав людини.
Besides, we closely cooperate with the European Court of Human Rights.
Крім того, ми постійно на зв'язку з Європейським судом справедливості Європейського Союзу.
We also cooperate permanently with the Court of Justice of the European Union.
Ми постійно проводимо міжнародні конференції, на які запрошуємо і вас.
We often hold international conferences to which we also invite you.
Це була конференція в липні, це зараз буде в нас конференція в жовтні. Тому, крім того, дуже дякую вам, що ви прийняли нас спостерігачем в асоціацію вищих адміністративних судів і державних рад країн Європейського Союзу.
That was were conferences in July, and there will be the conference in October. We sincerely grateful to you for our joining to the Association of the High Administrative Courts of European Union in the status of observer.
Це все в системі дає нам можливість в Україні забезпечувати судовий захист прав людини на наш погляд на належному рівні.
In combination, all of this gives us the possibility to ensure the protection of the judicial protection of human rights in the appropriate level.
Незважаючи на рашистську навалу, на ті тривоги, на ті обстріли і так далі, які є в Україні, і вони є у всіх наших регіонах України.
Despite the Russian invasion and air alarms, shellings and other horrible things of war in all our Ukrainian regions.
Тому, користуючись нагодою, дуже вам всім дякую за ту допомогу, яку ви надаєте нам у цій боротьбі з несправедливою війною.
And taking this opportunity, I would like to express my appreciation for your assistance, for your help in our fight against unjustified war against us.
Ми все робимо для того, щоб бути разом з вами у європейській сім'ї, щоб кожен громадянин України мав право на верховенство права, щоб наша Україна розвивалася як демократична держава і щоб основні цінності, права людини були на першому місці у нашій країні, як і у ваших країнах. Дуже вам дякую.
And together we make our best to join the European family, to ensure the human rights and the rule of law, and to make our citizens live in safe, democratic state. Thank you very much.
І ми обов'язково переможемо рашистів.
And we certainly will have victory over racists.
Дякую.
Thank you very much.
Thank you. Thank you very much, Honourable Justice Michail Smokovych, President, Supreme Cassation Court, Ukraine Supreme Court, for your response. Is there any question or any comment, final comment you want to make before I conclude the session? Honourable Justice Michail Pikramenos, President, Hellenic Council of State of Greece, Presidents and Honourable Justices, distinguished colleagues and esteemed participant, it is my great privilege to offer the concluding words for what has truly been an extraordinary session of the Global South Network Judges Guest Lecture Series. At the outset, I extend my deepest gratitude to Honourable Justice Pikramenos, President of the Hellenic Council of State, for his rich and thoughtful lecture on the Hellenic Council of State and its position in the European legal order. His reflections illuminated how a Supreme Administrative Court can operate simultaneously within national and supranational frameworks, safeguarding domestic constitutional values while engaging dynamically with the European Union law and the jurisprudence of the European Court of Justice and the European Court of Human Rights. We also have benefited from an exceptional panel of discussants. President Luis Alberto Alvarez Parra offered valuable insights from Colombia, highlighting the Council of State's unique dual role in both education and consultation. Justice Kari Kuusiniemi shared the Finnish experience, reminding us of the importance of the transparency and the governance in administrative justice. Justice Yves Gounin enriched the dialogue with the perspectives from France, a jurisdiction foundational to administrative law traditions, and also comparisons with different hierarchies of the superior courts. Honourable President of the Supreme Court of Appeal of South Africa, Justice Molemela, connected the South African experience where administrative law operates within constitutional supremacy framework to broader global debates, and Justice Michail Smokovych brought the urgent, poignant perspective of Ukraine, demonstrating how administrative courts uphold the rule of law even amidst profound national challenges. Together, these remarks have underscored both the shared commitments and the diverse realities of the Supreme Administrative Courts across Europe, Latin America, Africa, and beyond. What strikes me most profoundly is how this dialogue reflects the very spirit of the Global South Network. The aim, which is bridging divides between North and South, between different legal traditions, and between theory and practice. We are reminded that while courts operate within distinct legal, cultural, and political context, the pursuit of justice, fairness, and accountability is a universal calling. Today's conversation not only deepened our understanding of administrative justice, but also highlighted the importance of international judicial cooperation in an age where challenges such as artificial intelligence, climate change, migration, and the protection of fundamental rights transcend borders. So too must our efforts to learn from each other and build collective resilience. And that is, by the way, the rationale behind the creation of the Global South Network is because as an academic, I personally observed that there are a lot of publications, a lot of books, a lot of articles, a lot of speeches, but there is always a lack of bridge between these different professions, communities, societies, and it's very important to provide a forum where the frank knowledge exchange and sharing good practices can occur during all times, be it war or be it peace. This should continue, and that was the reason that I thought it should be introduced. I would like to thank each of the Honourable Justice and participants for your time and your wisdom, your generosity in sharing your experiences. Your presence here enriches this platform and strengthens our mission to foster meaningful judicial dialogue across the globe. Let me conclude by reaffirming that the Global South Network remains committed to building bridges between the Global North and Global South, ensuring that voices from every jurisdiction, large and small, established and emerging, are heard and valued in shaping the future of law and justice. Thank you all once again for making this session such a success. I look forward to continuing the vital journey with you in months and years ahead, and building upon this experience. I would get back to you, and I'll continue. We remain in touch with you. Thank you very much. Have a great day. Great week ahead. Thank you very much.
Thank you.
Thank you. Bye-bye.
Bye-bye.
Thank you. Bye-bye.
Bye-bye.